I also want to bring in MSNBC legal correspondent Lisa Rubin, who has been inside the courtroom all morning long. Okay, Lisa, bring us inside that courtroom, your specific observations, and if you have clues to what the jurors may be doing here.
It's always difficult, Chris, to read the tea leaves based on juror body language. But I will tell you there were some points in time where there were more jurors taking notes than there weren't. And I've never seen such an attentive jury. All the body language was focused on Judge Merchan as he was rereading the jury instructions this morning. And there was one in particular that made me kind of stand up at attention, because this is when I noticed the pen writing pick up a little bit. And that's where they got to the definition of intent. And in particular, this part. In determining whether Donald Trump had the requisite criminal intent, the instructions say that the jury may consider the person's conduct and all of the circumstances surrounding that conduct, including but not limited to the following. And I'm on page 28 of the jury instructions for anyone who has them in front of them, either at the table or at home. What, if anything, did the person do or say? What result followed the person's conduct? And was that result the natural, necessary, and probable consequence of that conduct? That matters because Trump's own fingerprints on the falsification of the business records are few and far between. At best, he signed 9 checks to Michael Cohen. However, Michael Cohen places him at a meeting in January of 2017 with Alan Weisselberg, where he and Weisselberg go in. They've got a bank statement from Michael Cohen's LLC that reflects a wire transfer to Stormy Daniels' lawyer of $130,000. And then the document contains handwriting from both Weisselberg on the left, Cohen on the right, mapping out what that repayment scheme is going to look like. Cohen testified that Trump not only approved that repayment in 12 installments, but once he did that, sort of signaled to them, well, now that that's taken care of, D.C. is going to be a hell of a ride. In other words, he was almost signaling, well, we've gotten that out of the way. Now it's time to be president. And so, was it foreseeable to Donald Trump, having approved that repayment scheme, that would have happened? That is what the jurors are entitled to take into account when they're measuring whether Donald Trump had the criminal intent to falsify records, even if he didn't do the falsification himself, if he caused it, and if his intent was such that he could reasonably foresee what was going to happen after that meeting. If the jurors credit Michael Cohen's account of that meeting, they are likely, based on the recitation here that they were paying such careful attention to find that he did have the requisite intent, Chris.
Sometimes when you listen to what juries want read back, it's very difficult to see where they're going with it. Sometimes it can seem unrelated, or you're not sure how one part of it goes with the other part of it. Does it seem to you, again, we can't get into their heads, we don't know what the conversations are, but they're approaching this methodically, that it makes sense that the various things that they asked to have read today?
There is one part of what they asked for that makes perfect sense to me, or maybe 3/4 of it makes perfect sense to me. And then there's one thing that's still a question mark in my head. Let's go to the first part, the part that makes sense. Hearing David Pecker's testimony about the August 2015 meeting, just right up against Michael Cohen's testimony, I was struck, and I know our colleague Katie Tur was too, by the similarities between their two stories, told, literally miles apart, at least in terms of the presentation of evidence in this case, and yet their accounts are markedly similar. So again, to Deanna's point, if you are trying to assure yourself that you're not going to convict Donald Trump just based on the testimony of his accomplice, Michael Cohen, hearing those two accounts and hearing how well Pecker's account, which came first, corroborates that of Cohen, which he's been telling for years, that would be meaningful to you. The one thing that I'm still scratching my head about is that the jurors asked for a read back on Pecker's testimony about his decision not to go through with the transfer of life rights from AMI to Donald Trump. That's a transfer that he said he put the kibosh on after consulting with the General Counsel of American Media. Why the jurors wanted to hear that in particular, it's still leaving me scratching my head, because it was as a result of that decision that Donald Trump didn't end up purchasing Karen McDougal's life rights, and that the party that made that purchase and in the end made a contribution that the FEC and the Southern District of New York, the federal prosecutors, decided was an unlawful campaign contribution. they did that and were left holding the bag because of David Pecker's decision to call off that deal, not Donald Trump's. It may be important to the jury to remind themselves that it wasn't Trump who backed out of the deal, but in fact it was Pecker based on legal advice that he received. And I should note, he never detailed it. The judge was careful to guard the attorney-client privilege between Pecker and his lawyer. But the implication was Pecker ran this by an in-house lawyer. The in-house lawyer basically said to him, this is a no-go. And he was concerned enough to call Michael Cohen and in his own testimony, tell Cohen to rip it up, at which point Cohen said to him, again, according to Pecker's testimony, the boss is going to be very angry with you.